First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning and welcome to the First DCA via Zoom. We have one case this morning, JEA versus Zahn, which is 20-3390. Apologize, we were a minute or two late with some technical difficulties on our end. If we have any difficulties during the course of the OA, certainly that won't be docked against your clock, and we'll get that sorted out. But our counsel for appellant and appellee ready to proceed?
We are, Your Honor.
And would the appellant like to reserve some time for rebuttal?
Yes, Your Honor. We would like to reserve 3 minutes for rebuttal.
Okay, then you have the clock there, but we'll also try to help you monitoring it. So, counsel, if you're ready, please proceed.
Thank you, Your Honor, and may it please the court. The two most important words for this court to render its decision in this appeal are the words "this agreement." Those words limit the scope of an otherwise broad arbitration provision to only those claims that arise from or relate to the contract between the parties. Because standard rules of contract construction apply, those words are to be afforded their plain meaning. And the plain meaning of the words "this agreement" is this contract and not this employment relationship. The circuit court improperly expanded the scope of the arbitration provision by comparing JEA's claims to the employment relationship between the parties and not to the contract. The court effectively rewrote the parties' agreement to expand the scope of the arbitration provision to include all claims between the parties and not just those claims that bear a significant relationship to the parties' contract.
Well, you agree this is a broad arbitration agreement under Seifert and all the other cases, right?
Yes, Your Honor. There's no dispute that this is a broad arbitration provision under Seifert.
Well, the connected with and/or otherwise relating to this agreement, doesn't that to some extent concern Mr. Zahn's duties to JEA, including his fiduciary duties that any executive would have, as well as any contractual duties?
It does not, Your Honor. So the Seifert analyzed basically two types of arbitration provisions, those arising from an agreement and those arising from or relating to an agreement. The broader provision, which is what we have here, there's no case in Florida that talks about this specific language, but Seifert does not make any type of distinction between a narrow arbitration provision, a broad arbitration provision, and perhaps a super broad arbitration provision. So what we have here under Seifert is the broadest that it can possibly be. What Seifert stands for is the proposition that even in a broad arbitration provision, if it's limited to this agreement or words to that effect, that means that it does not include independent tort claims that arise under Florida common law.
Well, and Seifert was, certainly an independent tort claim with, a wrongful death action. Although the fiduciary duties seem a little more intermingled with the contractual duties. But what about the language right after what I read you, where it says the arbitrability of any controversy or claim related hereto shall be finally settled by binding arbitration? So doesn't that mean that the issue of what is arbitrable has to go to arbitration?
No, Your Honor, it does not. So no party has raised that issue. It wasn't before the trial court, but in any event, the Seifert makes clear that the arbitrability analysis is the court's in the first instance. So we believe that we are properly before the court and that Seifert does apply, and it should apply to allow these claims to proceed in litigation.
Well, do you agree with CT Miami and various other cases that say any doubt with regard to arbitration, whether it should be sent to arbitration or not, should be resolved in favor of arbitration?
Your Honor, we recognize that Florida does have a policy that favors arbitration, but that policy only applies where there is some doubt or ambiguity. Here, there is no doubt or ambiguity. The parties haven't suggested that there is one, and the plain meaning of the provision in the employment agreement is clear. The words "this agreement" are not ambiguous, and so there's no policy in Florida that would trump the unambiguous language of an agreement between the parties. So while the policy is typically important and may tip the scales in the case of an ambiguity, we don't have that here. What we have is the real issue, the core of the arbitrability analysis is one of consent. It is whether or not the parties, by the plain meaning of the words that they use in their agreement, have demonstrated an intent and agreement to arbitrate certain types of claims. So our argument is that the parties, by selecting the language "this agreement," agreed to limit the scope of the provision to only those that bear a significant relationship to the parties' contract. And so under Michaels, Seifert, Boone, and most recently Saunders, all cases which interpret arbitration provisions that are limited by words "this agreement" or words to that effect, that independent tort claims that arise under the common law are not included within the scope of those arbitration provisions.
Counsel, is there any significance to the fact that this arbitration provision appears for the first time in the third employment contract, and yet it's being applied sort of retroactively to previous conduct?
Yes, Your Honor, that's a great point, and one that I was hoping to be able to make. There are no cases in the state of Florida that allow for an arbitration provision to be applied retroactively to, in some ways, redefine an employee's fiduciary duties while he is an employee. There are cases from outside of the state of Florida. There are federal cases, particularly those from the 6th and the 11th circuits, that talk about the ability for an arbitration provision to be retroactively applied. In those cases, the circuit courts have held that the language cannot simply include a reference to "this agreement." They must include some more broad language. So for example, cases that arise or claims that arise from or relate to the relationship between the parties, that has been held sufficiently broad to allow a retroactive application of the arbitration provision. But because we don't have those broad words in this provision, then it cannot be applied retroactively.
Well, wasn't it allegedly one whole scheme, though? There wasn't a scheme before July 2019 and then a new scheme or new tort post 2019. I mean, practically, how would that work? Some of the I guess all of the pre-2019 allegations would be in circuit court. Some of the post-July 2019 would be arbitrated, and some would be in circuit court. I mean, it seems practically kind of difficult.
I understand the court's concern, but our position is that, and the way that the complaint is drafted, is that all of the allegations of the complaint, specifically those that relate to JA's fraud and breach of fiduciary duty claims, accrued before the execution of the July 23rd, 2019 employment agreement. There was a board meeting that day at which the JA Board of Directors approved 3 different resolutions. One authorizing the continuation of a sale process, 2, the approval of the performance unit plan, which would have netted executives and public employees hundreds of millions of dollars in the event of a sale, and the employment agreements, all 3 of which were approved at the same meeting, but the employment agreement was not executed until after the meeting. And so all of JA's allegations regarding fraud and breach of fiduciary duties accrued prior to the execution of the July 23rd employment agreement, and therefore predate any arbitration provision.
And kind of related to that, the injunction claim that you contend is specifically exempted from the arbitration agreement. But part of that will be moot, I guess, depending on what we decide. One of the things you sought to enjoin was the arbitration. So Judge Wallace and now us get the crack at that. So that seems to be moot. The other portions of it, though, just seem to be related to contractual claims, kind of a disgorgement or obligation to pay. What do you say about the ability to pursue the injunction claims under the arbitration agreement?
Thank you, Your Honor. There are two different arguments. They both apply the same concepts of requiring the court to enforce the plain meaning of the parties' words within the contract, but it's slightly different because with respect to the injunction claim, because it's expressly accepted from the scope of the arbitration provision, an injunction claim could address issues that arise from or relate to the parties' agreement, because those claims are expressly accepted from the scope of the arbitration provision. And so it's okay that JEA's injunction claims may implicate some parts of the employment agreement because that claim is expressly accepted from the scope of the provision. I want to talk very quickly about JEA's fraud claim because it's different than the breach of fiduciary duty claim. So JEA's fraud claim is not based on the concepts of relationship or duty at all. It is based on allegations that Mr. Zahn made material misrepresentations to JEA's board, to JEA's customers, and to the public at large. Paragraph 28 of the complaint says that Mr. Zahn was, that he knew or was reckless in not knowing that statements he made to the board contained material misstatements and omissions, and that statements he made to the public were materially false and misleading. So the subjects of the fraud are the potential sale of JEA and the performance unit plan. The misrepresentations that he made were not just to JEA's board, they were also to JEA's customers and to the public. None of these things are talked about in the employment agreement at all. And so there is.
But I mean, those misrepresentations that he allegedly made, if he was just a citizen of Duval County, not the CEO of JEA, those wouldn't be related to the arbitration agreement, but he is or was the CEO of JEA. So doesn't those claims still seem somewhat related?
They don't, and here's why, Your Honor, because that is the real issue. That is the heart of the error in the trial court's order. And the argument is it's the concept of relationship. So Seifert says you have to compare the claims in the complaint and the party's contract and not the party's relationship. That is the holding of Saunders, the recent 5th DCA case from 2017, which expressly rejected this relationship test as contrary to Seifert. So what Saunders held was that although the employment agreement created the legal relationship between the parties, her claims did not directly relate to the contract itself. So as a result, the claims could proceed in litigation. I see that I'm running into my rebuttal time a little bit, and I apologize.
Okay, so we'll reserve the rest of your time for rebuttal. Thank you, counsel. Counsel for appellee, ready to proceed then?
Yes, Your Honor, thank you, and may it please the court. Part of JEA's argument here is that their tort claims are wholly independent of the employment agreement, and that is simply not so. The nexus required by the Seifert analysis is clearly shown by referring to the allegations of JEA's complaint itself. And you can clearly see that in their fraud claim, their breach of fiduciary duty claim, and their injunctive relief claim. And to take each of those on. In the fraud claim, it's alleged in the complaint, paragraphs 28 and 29, that Mr. Zahn engaged in material misstatements and omissions to JEA's board, and also, as Mr. Wedekind said, to the public, but they emphasize Mr. Zahn's relationship to the board. And in paragraph 29, that Mr. Zahn made these misstatements and omissions with the intent that JEA, through its board, would act on them. That's the heart of the fraud claim. Similarly, the breach of fiduciary duty claim, count 2, the heart of the breach of fiduciary duty claim, of course, is Mr. Zahn's relationship to JEA's board and the allegations that are made in the complaint that Mr. Zahn breached all those fiduciary duties. Now, what defines Mr. Zahn's relationship to JEA's board? Well, of course, that's the employment agreement itself. And the employment agreement is very specific in talking about the duties that Mr. Zahn owed to JEA's board. Number one, as you've seen in our briefs, we emphasize paragraphs 1.2, 1.4, 1.5 of the employment agreement itself refers to Mr. Zahn's duties, Mr. Zahn's fiduciary obligations, and so forth. It's also important to note that section 1.4 of the employment agreement expressly incorporates and attaches as Exhibit A to the employment agreement a 3-page long position profile. It's really a job description for the CEO's position. And that job description or position profile attached as Exhibit A to the employment agreement very specifically defines and describes Mr. Zahn's relationship and his obligations to JEA's board.
Well, how far though does this go out? I'm not saying this happened here at all, but just kind of stretching the limits of this. Say a CEO is fired, and at that point the CEO produces an arbitration agreement. The arbitration agreement is clearly fraudulent, clearly the result of undue influence. The whole contract fraudulent. Says you can pay him $1 billion on filing, something like that. Is there no way short of arbitration for the employer to contest that arbitration agreement?
I think I understand your point, Your Honor, and I don't think that's exactly the case we have here.
Well, and I'm not saying it is. I'm just trying to say how far do we go with your argument here as far as arbitrability when fraud is alleged?
I think it really does come down to that Seifert analysis, and the Seifert analysis is very clear and very plain. And as the Florida Supreme Court held in Seifert, there has to be some nexus between the dispute or the claims and the contractual relationship. Here, we think that nexus is very clear, Your Honor, because of the detail that's in the arbitration agreement, the detail that's in the employment agreement, which contains the arbitration clause. That relates, there is clearly that nexus or relationship between JEA's claims here and the employment agreement itself, especially with reference to the position profile. This is not a case like, for example, the Seifert case where a wrongful death claim was wholly independent of the real estate contract that had the arbitration clause, or some of the recent cases you've seen, such as Saunders and Boone, which were employment cases where an employee raised claims about sexual harassment, sex discrimination, and negligence, things of this nature that had nothing to do with the employment relationship itself. Here, Mr. Zahn's duties again, that he owed as CEO to JEA's board are spelled out and referenced in the employment agreement with its attached position profile itself. And that goes directly, Your Honor, to what JEA is alleging with its fraud and breach of fiduciary duty claims. They're all tied up with trying to show Mr. Zahn breached those duties. Therefore, the bottom line—
Counsel, does the PUP provision provide the required contractual nexus in and of itself?
I think so, Your Honor, in that what's alleged is that Mr. Zahn and the promotion and the discussion about the PUP plan and all of those other aspects that were brought up during his role as CEO are very much tied to this identification and description of his duties under the employment agreement. So yes, Your Honor, we certainly think that you can't divorce the two. All of the claims of fraud and breach of fiduciary duty that are alleged, all of those allegations relate to and depend on Mr. Zahn's role as CEO and how that role is defined in the employment agreement.
Well, can I take you back to Saunders for a minute? I mean, the person there, Dr. Saunders wouldn't have had a sexual discrimination claim unless she were an employee of the appellee. So I mean, a person on the street couldn't sue for sexual discrimination. It might be gross, it might be some other tort, but it's not sexual discrimination or sexual harassment. So can we agree with you and not conflict with the 5th DCA?
Yes, Your Honor, certainly. And because as the 5th DCA outlined in Saunders is, you have to look at more than just the parties' relationship. The fact that someone is an employee doesn't mean that any claim that that employee may have or any claim that may be brought against that employee is tied to the employment agreement. It's beyond it's more than a relationship test. I think this is true from Seifert and the cases under it. So certainly we're not trying to argue that this court has to rule in any different way or inconsistent way than the Saunders case, for example. But what it depends on and what this court is called upon to do was laid out in the Seifert case, of course. And this court has to look at what the reality is, the reality of the claims alleged and the conduct alleged as part of those claims, and what the underlying agreement containing the arbitration clause relates to. Here, of course, there's no allegations of fraud or breach of fiduciary duty outside of Mr. Zahn's employment status and his relationship as the CEO of JEA. All of the claims are really bound into that and relate to, which is why we say the bottom line here is that these claims, fraud and breach of fiduciary duty, can't be decided without some reference to the employment agreement. They are not wholly independent of the employment agreement at all. That's why this case is unlike the Seifert case or unlike the Saunders case, for example. Instead, this case is very much like the Burke versus Windjammer case, which was, again, a dispute between a corporation and its CEO. And in that Burke versus Windjammer case, the employer sued the CEO, former CEO, for allegedly breaching his fiduciary duties. The court there properly held that was in connection with, and his employment agreement, which helped define those fiduciary duties, was related to. There was that nexus. This case is also more similar to the Kaplan versus Kimball Holmes, the McGuire versus King, and the Jackson versus Shakespeare Foundation Florida Supreme Court case. All of those cases arose in a real estate contract context. In those cases, there were tort claims for fraud, for example, and the question was it related to the contract? In each of those cases, the courts held that yes, the tort claims for fraud were tied up with and tied into the real estate contract. That's how those cases were different from the Seifert case, where the wrongful death claim was wholly independent of the real estate contract. That's how all of those cases, Jackson, Kaplan, McGuire, are still consistent with Seifert, even though the ultimate analysis was came out a different result, because the ultimate analysis does depend on applying the analysis to what are the claims alleged, and do they relate to? Is there some nexus with? Is there some nexus with the employment contract? Here, it's clear that there is.
Can I ask you, how does the arbitration agreement, if it applies at all, apply to anything before July 2019?
It does, Your Honor, because the employment agreement itself references and incorporates an effective date of November 27, 2018. Why does it have that effective date? Because Mr. Zahn had been the CEO for all of that time, since November 27 of 2018. The employment agreement refers to that and refers to this agreement supersedes any prior agreement and incorporates that entire time of his relationship. Again, there's no allegations of fraud that don't relate to or were outside of the scope of Mr. Zahn's duties as CEO and his performance in that role as CEO, reporting to and acting with JEA's board. With respect to the injunctive relief claim, because I wanted to address that, as you know, there's a narrow exception to the broad arbitration clause here for injunctive relief claims. But here, as we pointed out in our brief, the particular injunctive relief claims asserted here are very much tied into the employment agreement. For example, what JEA alleges is they asked for 3 types of injunction. The first one was to enjoin the arbitration proceeding from going forward, which, as you pointed out, Judge Bilbrey, is something that we're obviously here for, and it's essentially mooted. But the second injunction request that JEA makes is alleges that Mr. Zahn should return any amounts paid to him under the employment agreement. The third injunctive relief claim is to prohibit JEA from paying Zahn any amounts owed under the employment agreement. That clearly shows how those claims are tied into the employment agreement. There's again that nexus that the Seifert court requires us to find. And of course, here, those injunctive relief claims we allege were artfully pled as a way to try to get around the arbitration agreement. When you do the Seifert analysis and look at what the claims allege, as I just stated, those claims depend on a reading of and an analysis of the employment agreement. And frankly, they're claims that are ultimately to be determined through the arbitration process. This isn't a question of threshold injunction where something must be done, within 10 days, within 14 days, a typical kind of injunction claim where immediate relief must be exercised. That's, I think, why there's that carve-out language to begin with. But instead, JEA has pled injunction claims that by their very own language, by the very own words that JEA used in its complaint, are wholly dependent on and relate to interpreting the employment agreement itself. That's why the fraud, the breach of fiduciary duty, and the injunctive relief claims here are so tied into, are so connected with the employment agreement and the need for the interpretation of the employment agreement that you can't say that these are wholly independent and must be outside the scope of the arbitration agreement to be determined in court. These should be decided in arbitration with the remainder of the claims, which JEA has already conceded now. It's not part of their original argument, but they've conceded now that their claims for breach of public trust, fraudulent inducement, they've already conceded those counts 3, 4, and 5 are part of the arbitration process. There's no reason for the analysis to be different, as Judge Wallace decided at the circuit court level. Whether the claims predated the execution of the employment agreement was immaterial to Judge Wallace for the reason that the agreement itself incorporates the entire relationship period between, that Mr. Zahn served as CEO.
Any other questions from the panel? Thank you, counsel. I think we ask all we can of you then. Thank you. We'll turn it back to appellant then.
Your Honor, in response to one of the court's questions of Mr. Mullen, I want to quote directly from the language of Seifert. And that goes to how you define what is or is not a significant relationship between a claim and a contract. Seifert at 638 says, quote, "For a tort claim to be considered arising out of or relating to an agreement, it must, at a minimum, raise some issue, the resolution of which requires reference to or construction of some portion of the contract itself." JEA's claims, particularly its fraud claim, and it just does not require any court to refer to or construe any part of the employment agreement. The position profile that's attached as Exhibit A looks like a job posting that you would see on a website. It generically describes the CEO position and what the responsibilities of a CEO position is, but it doesn't impose any duties on Mr. Zahn, and JEA's claims are not based on his violation of any of the different descriptions contained within the position profile. Jackson, Kaplan, and McGuire are all distinguishable because the subject of those fraud claims was the contract itself. So the evidence of the damages in that case was the contract. Windjammer is inappropriate because its analysis was dicta. The holding was, that was a waiver case, not an arbitrability case. In closing, there's a straight line between Michaels through Seifert, Boone, and Saunders to the facts of this case. In all of those cases, the court interpreted broad arbitration provisions that were limited to claims arising from or relating to this agreement, or words to that effect. And they determined that independent tort claims brought under common law could not be compelled to arbitration. The same reasoning and the same result should apply here. So the court should vacate the order on appeal and remand with instructions that these 3 counts proceed in litigation.
Thank you, counsel. Thank you both. The case is submitted. And with no further business to come before the court, we will stand adjourned. We appreciate the argument.